This is episode 68, and today we're talking about how to write a contract, which is a very important skill to learn and to understand. What's up, guys? Thank you for tuning in. Today we're talking about how to write a contract, and I think it's important to understand how to write a contract because contracts rule the world. I mean, no matter what you do, no matter whatever transaction is going on, particularly if you're changing money for a service, there's a contract in place, whether it's an employment agreement, whether it's a real estate agreement, whether it's buying a car, buying a house, I mean, whatever it is, there is some type of contract, and we sign contracts on a daily basis, whether we really know it or not. We download an app, we agree to the terms and services. So there's typically a contract that's governing our daily lives. So today we're talking about how to write a contract. Contracts are very important. I know individuals come up to me all the time for free legal advice. So one of the reasons I created Global Law Media is to teach people how to understand their rights, and we're going to teach you how to write a contract. Because contracts are very important. Because it's important because just because you can't afford the services of a lawyer doesn't mean you shouldn't have access to the law. Doesn't mean you shouldn't necessarily know about how to write a contract or know certain aspects of the law and be able to perform your legal services on your own. So that's why we created Global Law Media, so individuals can actually just learn it and then apply that to their life so they can achieve whatever things they want to achieve in life and some type of success they want in life. So because that's very important. But I do want to caveat by saying that every contract doesn't have to be written. You don't have to have a contract written down on paper. It can be what they call a verbal contract. A verbal contract is a contract that's not written down. It has all the elements to make a contract. It has an offer, has an acceptance, consideration. I offer something, you accept that offer, and there's consideration. We're exchanging things. It can be a service for money, it can be a product for money, it can be whatever it is, but those are the three elements of a contract, and they don't have to be written down, but it is advisable to have it written down. And why do I say that? Because here's just a very basic example. Say for example, you go to a person and say, I want to buy your car. This person has a blue Toyota, for example, and you say, I'm gonna buy your car for $3,000. And the person comes to you and say, here, I agree to it, wire me the money, and you send the money to the person, and the person comes and delivers you the blue Toyota. But it's not the blue Toyota you mentioned, but you all agreed to buy your blue Toyota. But what you didn't know is that him and his wife, they may have had twin cars or similar Toyotas. The car you may have said that may be 50,000 miles, but the car you brought has 150,000 miles. So just not writing the contract down, because in that contract you will put the VIN number is this, you will put the description of it, the mileage on it, all this and things such as that. It will be written down on paper, so you can govern it and take it to court if a person doesn't deliver or give you what you want. But that could be somewhat of a silly example. But another example could be when you're dealing with cross-border, dealing with different countries, because the United States isn't the only country that has a dollar as their currency. For example, there's the US dollar, there's the Canadian dollar, there's the Australian dollar, there's the Bahamian dollar. So just because you say I want to buy something for $2,000, if you're dealing with another country, a person from another country, they may come and give you Australian dollars. And then he's like, no, you're not getting my car for Australian dollars. I want US dollar, but you didn't say that you didn't say pay me in US, 2,000 US dollars. You never said US dollar, you just said dollars. So that's important to have a contract because you can easily put 2,000 USD, which is short for United States dollars. But let's talk about how to write a contract. There's typically 4 important sections of a contract. There's an introduction, there's the agreement, there's the general terms, and there's a signature. So let's talk about the introduction now. The introduction, out of all those segments, introduction may not be the most important, but it is very important. Everything in a contract is very, very important. So let's talk about the introduction. The introduction primarily, it introduces the party, who it may be, whether it's an individual, or whether it's a company. It introduces those parties. And also in introduction, it has a recital. Generally, they have a recital. Most well-written contracts have a recital. And a recital pretty much is a short description of what this contract is. So if you read that short paragraph, maybe 1 sentence, could be 2 sentences, 3 sentences, whatever it may be, you typically understand what this contract is about before you read the rest of it. It can be about this painter desires to place his art into his art gallery, and this art gallery desires to lease space in this art gallery to this renter, or this person desires to act as an independent contractor for this X amount of services company, and this company desires to hire this person as an independent contractor. So it typically quickly explains what this contract is about. So that's the introduction. And then you get to the agreement section, and this probably is the most important aspect of a contract, because it deals with the services and the money. And if you don't get the services and the money right, then the contract isn't right for the most part. And that deals with the terms we talked about earlier, those 3 terms that comes with a contract: an offer, an acceptance, consideration. Like it'll say, for example, it'll flat out say, John agreed to provide services blank to company, and in consideration for these services, company shall pay John $5,000. Boom, right then there's offer, there's acceptance, and there's consideration. There's offer because he said, I'm going to offer my services to you, and they accepted that. And there's a consideration for your services. That's a consideration, which is I'm giving you money in exchange for your services. They both agree and bargain to these aspects of this, so that is your contract. So that is the critical aspect of it. In the contract, you'll typically see the services written down. The services can be anything. It can be anything. I mean, I agree to fix your house. I agree to fix this item. I agree to work at this place a certain amount of time. I agree to perform these services. The services can be anything, and oftentimes they'll be listed under the services heading. But if it's too many services, they may say John agrees to provide the services as explained in Exhibit A. And then the services will be, if it's a bunch of services, like it may be 20 services that this person agreed to provide, then that may be in a separate document called Exhibit A. But that also is equally important, because a clause that we'll see in later on, it'll say all attachments, and this agreement is entirely the sole agreement, including all attachments. And so you incorporate those attachments into the document as if it is one complete document, which it is a one complete document. So that's very important. Also in the agreement, it talks about the duration, the term, how long will this last. For example, you rent a house, is this rent going on forever, or is it going on for a year? Or if the person is doing a service, does the contract end once the service is performed, or do you keep have to paying this person month to month to month? What is the terms of this contract? So that's very important. Also, termination of this agreement. If a person doesn't like what's going on, can they terminate? Or the person performing the service, can they terminate? And if they do terminate, what happens? Do they have to pay some type of fee? Have to pay some type of fine? Or what could it be? When can a person terminate this contract? And if they do terminate it, what happens? What happens? Do we have to go through reconciliation? Whatever happens. So those are the most important parts of a contract. And there's many aspects of the agreement section, but those are the most important parts of the agreement section. Then I guess the third aspect of it is what they call the general terms. They may call it the boilerplate terms, or they may say miscellaneous. But these are not insignificant terms. Everything in a contract is there for a reason. That contract is ironclad. The words are there for a reason. No one just putting in words into a contract for no reason. But out of the aspects of a contract, if you were to rank them, these necessarily wouldn't be as important as the actual agreement section of the contract. And you typically see the same type of what we call boilerplate terms in a contract. For example, you'll see confidentiality. Terms between this contract are confidential. You also see things such as indemnity, which means like if something bad happens, you have a right to protect my interests. And for example, if you are, there's a lot of contract. There's a lot of examples with contracts. But I guess, for example, you are performing, you're a subcontractor or you're a general contractor fixing up a house or building a house. And if something bad happens, the developer is going to say has an indemnity, where the general contractor has to protect the developer from getting sued. Only the general contractor can get sued, and it goes on and on and on and on. It goes on and on and on. I mean, that's just one example of how it may be, but that's an important aspect of a contract. Another general term is the force majeure. You saw a lot of that this year in the global pandemic. Is ideas that I can end this contract without any type of penalty whatsoever, because these things are out of my control. These are what they call acts of God. A global pandemic is an act of God. Now, what happened was that a lot of contracts did not have a global pandemic as a force majeure. They did not have that in the contract. These things are contracting something that's out of control. Oftentimes you'll see if it's like a house and a building it and a hurricane comes and destroys it, that's out of control of both parties. That was an act of God, or lightning, or something they could not control or foresee happen. Then they can just end the contract and everyone can just walk away. But a lot of people did not have that global pandemic in their contract as counted as a force majeure, and that causes a lot of issues. So to have a well-written contract, that's another reason to go to another attorney, because all these issues, when you say I want to buy something or I want you to do something, you're not going to be thinking about all these terms just boom, 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 boom in your contract. And it's important to have that in your contract. What else is in the miscellaneous aspects of it? Choice of law. That's very important. Where can we sue? If you are in Georgia and the person is going to perform a service for you in New York, and something goes wrong, which laws are going to govern it? New York law or Georgia law? Because it may be inconvenient for the person in New York to come down to Georgia to litigate a case. So whose laws are going to govern? Oftentimes you're dealing with businesses, particularly multinational businesses, like for example, like a Pepsi or a MasterCard or whatever. They incorporate it in Delaware. So they say Delaware laws will govern because Delaware laws are typically friendly towards businesses. So you see a lot of that, and also international contracts. Whose laws are going to govern? I mean, if you're dealing with a developing country, their court system may not. What do I want to say? They may be what they call a hometown bias. They may, and that's also in developed countries as well. There may be a bias towards ruling in favor of the company that's headquartered in that country. So you can maybe do a third party country. You can say on some type of international arbitration agreement, under the New York agreement, or some type of international agreement, these laws will govern if something bad happens. And that's very important because laws are different. There's common law and there's civil law as well. So that's equally important as well. What else? And then assignment, and that's another clause. You cannot assign this contract to someone else without my permission. Let's give you an example. Say, for example, you hiring somebody to paint your picture. For example, this is a Jean-Michel Basquiat. This is a print. It's not the original. But if you hire a person like a Jean-Michel Basquiat or a famous painter, I want that person to paint my picture. I don't want you to assign it to someone else, because oftentimes individuals, they'll get your money and they'll say, okay, I'm gonna assign it to this person. How about you make the painting for me? Or how about you do this service on my behalf? A lot of times general contractor will hire subcontractors, but the person may not want a subcontractor who he doesn't know. He came to a general contractor because the general contractor is a state of the art, is one of the best general contractors or the best designers of buildings. I don't want you assigning it to someone else. I want you to do it. So they can have in their clause, you cannot assign any rights in this contract to a third party. So that's very important. And then the last section is the signature. It has to be signed. One of the reasons you sign a contract is because it shows intent, and that's important. One of the important aspects of a contract is offer, acceptance, consideration, and intent. I like to add that last part, intent. We intended to enter a contract. You cannot force someone to sign a contract because that contract will be voided because there's no intent. I didn't intend to sign it. I only signed it because you put a gun to my head or you forced me to sign it. So by signing it, that shows a level of intent. So those are typically the aspects of a contract, and I hope you all have learned something from this video, and I hope you all can continue to become better entrepreneurs and better individuals and better just well-rounded, have a holistic perspective on education, because you never stop learning. I hope you all never stop learning, and that's one of the reasons we created Global Law Media, because individuals can come here and learn about every aspect of the law, because the law touches every aspect of society. I mean, no matter what industry you go into, there's either a law or there's a regulation governing that type of industry. It does not matter where you go. Any industry in the world, in most part. And if it doesn't, it will very soon have a regulation governing it. So that's very important. And I have big dreams for Global Law Media, and keep coming with your questions. And then we're gonna grow this out. We're gonna keep expanding this thing. We're gonna grow it, and I'm determined to make it a success. But I hope you all have learned some things. And to recap, we taught you how to write a contract. That's what I want to hopefully that you all learn from this. That's the most important aspect. Just the recapping it is we taught you how to write the elements of a contract. So that's very important. The four aspects of it: the introduction, the recital, the agreement, the boilerplate terms, as well as having the signature. Those things will, if you can get those down, you're gonna have a pretty strong contract. It's probably advisable for you to take it to an attorney, but you still have a very strong contract nevertheless. And I hope you all have enjoyed this video. And we're one step closer to 1,000 episodes. Thanks.